same thing that the study found, that it is an exploited class, and that taxes need to be paid, wages need to be fair, and benefits need to also be fair. And with that, I would ask the committee for an aye vote.
Is there a motion?
I'll move the bill. And I did have just one comment or question, if I may, Mr. Vice Chair. Thank you, Mr. Swanson, for bringing this important legislation forward. I just wanted to clarify, I also have a port in my district. It's called Port of Sacramento, even though it is in the port of it is in West Sacramento, just like the River Cats are.
Very fine port.
River Cats are in West Sacramento, not Sacramento. But anyway, and they're not leaving town. So, there is nothing in this bill that would eliminate the opportunity for an owner-operator to extend employment to, 3 to 5 to 10 other individuals. Is that correct? I mean, one of the statements by the opposition or the concerns expressed is that there are some owner-operators that may actually employ 3 to 5 to maybe 10 other drivers. So I don't get the sense that that is the intent of your bill.
Sure. And I'm going to ask Mr. Barry Broad to respond on behalf of the Speaker on that.
We're talking here about a single truck driver with no employees and no business license. So anyone, and I'd like to remind people, I'm not sure the people in the trucking industry themselves know this because they don't make use of this, but you can be an owner-operator who is an employee, and there are federal leasing rules for trucks. You lease yourself and your vehicle. You get 2 checks. It's common. It exists out there. We're not trying to stop entrepreneurialism. The gentlemen that were here, whoever wants to go in the trucking business can go in the trucking business under any model they want. In the end, they need to get operating authority to be a trucking company. And if they have employees and they're making a payroll and they have a business license and they're doing what they need to do, what we're talking about here is a single truck driver who has nothing but himself. And that's it. And we don't want to, if people want to go into business, more power to them. But they shouldn't be made to go into business against their will.
Thank you.
Any other questions from our committee members? Is there a motion? Did we had one? Call a roll.
Swanson.
Swanson, aye.
Swanson, aye. Morell. Morell, no. Alejo. Allen. Allen, aye. Furutani. Furutani, aye. Gurel. Yamada. Yamada, aye. That bill is out.
Okay, Mr. Chairman, first of all, I thank the chair and the committee for their patience. I have 4 more bills. I would ask the chair to strictly enforce the time limit so that we can move through.
That'd be my pleasure.
Yeah, and I'm quite sure, Mr. Chairman, you're capable of being strict. So we're gonna move forward. I have AB 1136, employment regarding employment safety.
Move the bill.
And okay, that's great. Did I hear a second? Okay. Thank you so much, Mr. Chairman. Registered nurse manually lift an estimated 1.8 tons or 3,600 pounds per shift. Nursing surveys have shown that 83% of the RNs work in spite of back pain, while others leave the nursing profession because of back injuries associated with lifting patients. AB 1136 is designed to help ease the strain of patient lifting while preserving quality care for patients by requiring hospitals to implement a safe patient handling policy. Specifically, this bill would help increase the safety of healthcare workers and their patients by requiring hospitals to have a trained lift team or other support trained staff and safe lifting techniques at all times, and purchase enough safe patient handling equipment to eliminate the need for manual patient handling transfers by 2013, and documents the use of manual lifts after this equipment is purchased. I would ask my witnesses to self-introduce.
Mr. Chairman, Stephanie Roberson, on behalf of the California Nurses Association and committee members, pleased to sponsor this bill by Mr. Swanson. I think the chairman has laid it out accurately on the merits of the bill and why we support this. CNA and other supporters often, refer to this bill as a triple win policy. We say that for three reasons, obviously. Obviously for the patients. Our nursing workforce is getting older. Our patients are more obese, and the acuity levels are higher. And so there is much need for the assistance of the lift teams that are available on every shift 24/7 in combination with and depending on what the patient needs and whatever the hospital needs are. It's either equipment or lift teams. And we feel that that's necessary because if you look at our workforce, again, they're aging and they want to be phased out and they want to retire at some point. And we're talking about very small staff. And so when you stack that up against each other, they need those supports. For the workforce, you guys will be hearing a lot about workforce issues moving forward, and that's very important for us. 12% of the nursing workforce leaves the profession because they are hurting their backs, spraining their backs due to preventable injuries. So that's really important when we talk about, preserving our workforce and how we attract and retain their supports like this. And so that's why we need these lift teams to preserve the workforce. And not only that, the third point we want to talk about, the hospitals. You will hear, I'm sure from the hospitals, that they want some clarification on some issues, and we want to, with the chairman, of course, moving this forward, work with them on whatever they need. But I think they will agree, of course I don't want to speak for my colleague, but they have saved so much money in workers' comp costs, training and retraining new nurses. To date, it costs on average $60,000 to $140,000 to retrain a new nurse.
30 seconds.
Sure, thank you. And so those are preventable costs. Kaiser system back in 2003 had ramped up their systems quicker because they saw so many tremendous savings that they saw from their lift team policies. So with that, I want to have other people speak on this, but it's a triple win policy. Saves the hospitals money, saves our workforce, and prevents further patient harm. So we support this bill and ask for your aye vote. Thank you.
Thank you, Mr. Chair and members. Amber Wiley with the Association of California Healthcare Districts and the Alpha Fund. We believe that this bill will prevent workplace injuries in our hospitals, and patient handling is our #1 loss driver for workers' compensation claims. In 2008, our facilities incurred around $5.6 million just on patient handling claims alone in our facilities. Loss prevention measures, such as safe patient handling procedures required in this bill, will save our hospitals dollars and prevent injuries for our very valuable healthcare workers that we have a very hard time recruiting and retaining, especially in our very small rural hospitals where it's difficult to get the nurses to come to those hospitals, let alone after they've been injured. So for these reasons, I urge your aye vote. Thank you.
Thank you, Mr. Chairman and members. Brooks Ellison on behalf of the United Nurses Association of California, a proud member of ASME, asking for your support.
Mitch Seaman, California Labor Federation, also in strong support.
Anybody else in support? You can just, your name and your affiliation. If not, those in opposition, please. Come on up.
Good afternoon, Mr. Chair and members. Connie Delgado with the California Hospital Association. I want to start by saying this issue has been around in the legislative process for some years now. We want to make it very clear that the California Hospital Association has an opposed unless amended position because we really would like to see a safe patient handling policy issue really get resolved. But the problem is we need to have something that is workable in a real-world hospital setting, and this bill has some issues that need to be addressed specifically about emergency. Also, the latest set of amendments do pose some additional problems. Here with me is Karen Cawthon, the Chief Nursing Officer at Palm Drive Hospital in Sebastopol, to talk a little bit more about the bill.
Hello, my name is Karen Cawthon. Excuse me. And I'm the Chief Nursing Officer at Palm Drive Hospital. It's a small 37-bed acute care facility located in Sebastopol. I would like to testify that I'm opposed to AB 1136 as it is written. It is restrictive and does not consider resources and fiscal abilities of California hospitals, particularly small hospitals. I'd like to make myself perfectly clear. I'm very much a patient safety advocate and a staff safety advocate. In healthcare, everyone has to be We can't afford the lost days of work. We can't afford covering the injured staff or the liabilities associated with those patient injuries. Our facility, like other healthcare facilities, works closely with our insurance carriers, evaluating injuries and falls and determining how and what we need to do or purchase to minimize injuries to our staff and patients. Our facility recently emerged from bankruptcy and continues to sit tediously on the brink of solubility. Our facility is supported by parcel taxes of Sebastopol residents who desire to maintain a hospital in that small community. We don't have big budgets to hire extra staff to have lift teams. We don't have extra bodies lurking around every corner to have dedicated lift teams. We have 2 RNs in the ICU. It's a small ICU, only 4 patients in there. We have 2 to 3 RNs out on the med-surg floor that only has sometimes 10, 11 patients. 1 CNA or 2 CNAs at med-surg at the max, and 2 RNs in the emergency room with an ER tech. Our staffing levels must be maintained on those individual units at all times, so it's not always easy to pull people out of those areas to go and be a lift team on some other area. Like other California hospitals, we train our new nursing staff on proper lift techniques and the use of slides, gait belts, and lifts, and perform ergonomic and workplace assessments. Hospitals, there are certain areas that this doesn't seem possible. To have patients in CAT scanners, that would take lifts mounted in the ceilings in those areas, and that's very costly to do. An emergency room is a huge issue. To have a nurse standing by the bedside every time a patient is moved, that's part of this list, to say that they have to actually be there and observe this going on. That's, even if it's a physical therapist moving a patient. To say that a nurse can't use her skills anymore, her critical thinking skills, to determine whether or not she can lift a patient is a difficult thing to say to them. And it's going to be costly for us to continue to monitor that process also.
Thank you very much. Any other witnesses in opposition? Just state your name and your affiliation, please.
Mr. Chairman, members, Randy Perry with Aaron Reed and Associates on behalf of the 8 California Children's Hospitals. And that's it.
Did we have 3 people speak or 2?
2.
Oh, one more. Go ahead. I apologize.
I have no objection to this handsome
Yeah,
gentleman speaking.
that's fine. I thought we were on our 3rd. Go ahead.
Mr. Chairman, thank you very much. In addition to the comments made earlier, we have a couple of issues with the bill on behalf of the children's hospitals. Number one, there are amendment taken also that each time we lift, we have to document that and send the document in. It's an additional cost. And I appreciate work comp savings, representing employees as well. We appreciate work comp savings, but I don't think the cost to our hospitals of the machines, the extra staff, and the reporting required in the bill as currently written would outweigh any potential work comp savings for us. Finally, we represent, a lot of our patients are preemies and very, very, very small children. To require us to have lift machines and extra staff and the reporting each time they lift one of those preemies or lift a small child to do something and move them from here to here, to us is burdensome. So we'd like to work with the author. We understand the author does want to work and his sponsor want to work with us. We want to do that, and we'll continue to work with them.
Could I ask a question?
Yes.
I'm just curious, what percentage of our hospitals is sort of teetering close to the brink of just being not being able to pay their bills? Because I've talked to a few hospital CEOs, and I have a few of them that are
In the face of unfunded mandates, California hospitals are really struggling to make sure that we keep the doors open so that they're there when patients and the people of California need them. Exact percentages I don't have for you, but it is very difficult, and continuing to do something that, as was mentioned, would require hospitals purchasing enough machinery to eliminate manual lifts would add another layer of cost to hospitals that really may not solve the problem of lifting a patient properly.
Thank you. Was there any other names in opposition to this?
I wanted to, I'm sorry, any other?
No, none. So
Okay, great. And I wanted to respond to a couple of things if we could. The first is that we're completely open to sitting down and continuing the discussion as is the case, with all my bills. I like to do that. And the sponsors indicated they would like to do that, and so that's part of a very responsible way of approaching this. And then there was one other point.
Thank you for your indulgence. Thank you. Just a couple of things as we move forward. And again, we will work with folks and come to any kind of agreement that's feasible by all parties when the bill moves forward. But just a few things. One about RN judgment. I represent, along with my colleagues, 86,000 registered nurses in the state of California. There is no way that we would ever say that the RN judgment's not necessary in this bill. In fact, I don't have the bill in front of me, but the language states that the clinical assessment of the nurse is critical when making a decision of patient lift. So that's key. Number two, we're not asking for additional staff. It also said in the bill that the lift team members that are comprised to do the lifts, they are also there to perform other tasks necessary. So the way a lot of hospitals do it now is they use existing staff resources to make sure this happens. They're usually called a code blue, code red team, so this is not new staff. And then the equipment costs, we understand, are going down. They used to be $15,000 per equipment. Now they're $5,000 to $4,000. And hospitals, as you know, have the ability to access millions of dollars in tax-exempt bonds to purchase equipment. So just wanted to clarify those points.
Okay, would you like any questions from our committee?
I did have one, Mr. Morrell, if I may. Thank you, Mr. Swanson and Stephanie. What do you have to say in response to the lift teams having to go through the same process lifting preemies? Nothing in the bill that I read, did I miss something that would require a lift team to be available to pick up a child that might weigh less than a pound? It just seems a little spacious to me.
You're exactly right. I mean, there's nothing in the bill that has that specific requirement. We can make that clear if that's necessary. There have been, the policies out there with the Children's Hospital. They say that, well, we have babies in our hospital, so why would we need to be mandated to have a lift team? Well, when you look at the composition of children's hospitals, there are obese teenagers. So this has to be addressed at some point. So if we need to clarify that in the bill through the chair and working with him on what's feasible, we'll do that. But we just can't assume that children's hospitals are just staffed with babies.
Okay, point of clarification, please.
Yes, please. Assemblymember Yamada, on page 4 of the bill, the recent amendments do state that if a manual lift has to be used, document when and why it has to be used. There's no threshold. And when we talk about a manual lift, we're meaning just the moving. Also, I do believe repositioning may be included in there, but that would be whether or not you were propping up a patient in bed. So because of the ambiguity right now, we believe that this bill would require documentation for when you'd use a manual lift irrespective of the size of the patient.
Okay. And that's easy to clarify.
Right. Sounds like it's something easily handled. Thank you.
Go ahead.
So regarding the documentation concern, can't that be covered just the way it's done through charting? One would think.
Yes. And there's a lot of regulation in Cal OSHA already that requires lots of documentation. And so we've all talked about this internally with the language. And I don't know if folks want to clarify this point, but I think you're right. That's something that can definitely be worked out. So when working in a collaborative fashion, one of the stakeholders had suggested this language be added. We're actually kind of mulling that language over as we speak, and we'll be able to work that out. But I do agree. There's a lot of language, our existing law, that requires a lot of documentation and a lot of collaboration, committees, things of that nature that I think could be addressed in the regs.
Thank you.
Okay, quick clarification, please, for opposition. Fire away.
Mr. Allen, I am also a nurse. I still actively do nursing. And part of the way that you document in a chart is you document what you do for the patient. But if there are regulations and all of a sudden somebody's falling outside of the regulation or the policy that you create, that would be an occurrence. That would generate an occurrence report. The nurses are not typically likely that if they're going to use their better judgment because they think, well, maybe I can just lift this person up a little bit in bed, they're not going to really be likely to go in and say, oh, but I'm going to create an occurrence report on this because I could do this way, but I just actually broke my policy and procedure, so now I have to go and fill out the occurrence report. It's going to take them 15 minutes. And that's the part of you wouldn't normally document that in a patient record. You would normally document that on an occurrence report.
Yeah, I just would like to say this, and I know that both with the proponents and with the authors of this bill, you're going to work with the opponents, because I do realize that the situations are very different between Kaiser Permanente, the Sutter system, for instance, and I've toured Palm Drive. I'm familiar with it. I know the small hospitals are struggling, and I know that this can be a triple win situation, but it's not a one-size-fits-all either. So, and I'm hopeful that and I believe the proponents do recognize that. So thank you for coming today.
Thank you very much, sir.
Yeah, Mr. Allen, we would say that we certainly want a bill that will have a practical, positive effect. And I think the sponsors are very open, and we're going to continue the conversation so that we can clarify those things that are ambiguous and the unintended and avoid whatever unintended consequences there are there. Would you like me to close, Mr. Chairman? Okay. I just wanted to close on the bill by saying this, that I think partly I've been chosen as a member to carry this because I grew up with a nurse who was my mom, and my mom had to retire early because of back problems, and so I know from a real practical experience that this is something that has to be addressed. Now, how we address it and where we dot the I's and cross the T's and how we address some of the things there, then we will work on that. But the issue of whether we should address it, we must address it, and that's why I would ask you for your aye vote as this bill moves forward.
Is there a motion? Second. Call the roll, please.
Swanson?
Swanson, aye.
Swanson, aye. Morel?
No.
Morel, no. Alejo? Allen? Allen, aye. Furutani? Furutani, aye. Gurel? Yamada? Yamada, aye. That bill is out.
Thank you so much.
Mr. Chairman, we will try to move faster on these.
I lost control on that last
Yeah,
one.
I know.
Right out. I didn't even get to first base, did I?
Okay. AB 267, Choice of Law Bill. California is justifiably proud to have among the strongest worker protections of any state. Therefore, it's surprising that an employer can require California workers as a condition of employment to give up the protection of California law and can force California workers to travel to another state, even another country, to resolve an employment dispute that arose in California. Employers are able to do this by inserting choice of law clauses and form selections clauses in their employment contract with California employees. Not only are these clauses disadvantageous to California workers, they also give a significant advantage to the out-of-state employer who are able to utilize California labor yet remain unaccountable under our state's strong worker protection laws. This bill is not a blanket prohibition against these clauses. An employer may still voluntarily agree to them for separate consideration. AB 267 would simply prohibit employers from imposing them on California employees as a condition of employment. And I ask my witnesses to self-introduce.
Hi, my name is Eric Kingsley. I'm a private attorney in Southern California, appearing here on behalf of the California Employment Lawyers Association. And I think that AB 267 is very important because while this isn't a situation that we see happening on a daily basis, when it does happen, the results are catastrophic for the employee in question. When an employer can force North Dakota or Florida or some state that has very low labor standards laws, it basically means that the employee's claim could be non-existent. Where California may have a provision that protects them, the other state may have no protection for that same conduct. Likewise, an employee here in California, especially ones of limited means, will find it difficult to be litigating in all corners of the country, if not, in the U.S. Virgin Islands, for example, and would basically not be able to pursue that claim because of those forum selection clauses.
Thank you.
Sarah Flocks on behalf of the California Labor Federation in strong support of this bill. The labor movement and lawmakers like yourselves have worked very hard over the years to make sure that California has some of the strongest labor laws in the country, and yet some employers are able to undermine and avoid these protections, and workers are denied these basic rights in the state where they reside and work because of these employment contracts. And as we know, it's hard enough for a worker in California under California law to file a wage claim and to get unpaid wages or whatever claim comes up in the course of employment. It is that much harder, if near impossible, for a worker, especially low-wage workers, to have justice, to get access to justice when their claim has to be heard in a court 3,000 miles away under laws that they're not familiar with. So we think this is a very important bill, and we would urge your support. Thank you.
Lee Sandall with the International Longshore and Warehouse Union, and we are in support.
Thank you.
Any other witnesses in support? Any in opposition?
Thank you.
Good evening, members. Jennifer Barrera on behalf of the California Chamber of Commerce, and we oppose this bill. This bill primarily will impact national employers. An employer who has started their business here in California, who mainly is only in California, is not going to have one of these choice of forum clauses or choice of law clauses in their employment contracts. Rather, it's going to be national employers who have employment locations throughout the country who are going to have these choice of law or choice of forum clauses in their contract, and this bill will discourage them from coming to California. The problem is we already have protections in place through our court system for these provisions in a contract. The Supreme Court has said that they will analyze these provisions, and if they're unfair, coercive, deceptive, they'll look at the bargaining powers of the employees and decide whether or not the two parties had sufficient bargaining power to negotiate these terms of the contract and whether they're valid in the contract and should be enforced. The courts can look at this on an individual basis. What this does is basically say that all employees basically have the same bargaining power when that's just not true. There could be an employer, for example, a CEO working for a national firm who comes here to California and works here for several weeks or months out of the year and has sufficient bargaining power when they're negotiating their employment contract and can very well negotiate a choice of forum or choice of law clause, whereas maybe an hourly wage employee doesn't. But doing this one-size-fits-all kind of law doesn't look at that analysis and determine whether or not the parties had that sufficient bargaining power, whereas a court can do that independent analysis and look to see whether the provisions should be enforced. Another thing that I want to bring up that keeps getting brought up in this committee quite often is that these low-wage employees don't have a sufficient avenue to file a wage claim, and that's just not accurate. We have set up a statutory scheme here in California that incentivizes wage claims. We give an automatic right to attorney's fees if an employee even recovers $1 of their wages, and so there is a huge incentive for these wage claims to be filed and to have representation, because an attorney will always get their attorney's fees if they recover any wages on behalf of the employee. So there is definitely adequate avenues for these wage claims to be brought up and to challenge a contract that has these choice of law provisions. So we oppose, given that we just can't simply disincentivize national employers. They're the ones who can pull their business out of California because they're not stuck here in California or limited to California, and that's what we need to be concerned about. So we oppose. Thank you.
Catherine Pettibone with the Civil Justice Association of California. I know the hour is late, so I'm not going to reiterate many of the points made. We do enforce or believe in enforcing people's ability to contract and freely negotiated contracts. As previously mentioned, courts have thrown out clauses that didn't provide the same protections to California workers. We also would like to add that not all employees are the same. Think about sports professionals or highly paid entertainers. A choice of forum might actually be somewhere else and more convenient for them, and they should be able to negotiate that. We also would like to add that there are other states that have some very highly developed law that we actually benefit from using here. For instance, corporations law in Delaware. Californians benefit from that use of that law, and therefore this broad approach would preclude that. For these reasons, we oppose.
Any other questions from our committee?
Yes. Like to close, Mr. Chairman?
Can I say something?
Yes, you can.
You know, I still see things through the lens of a business owner all my life, so this is new to me. Some of these bills, just as we proceed, I just want to ask you to be cautious. It does, from my perspective, look like a lot of these are just going to hinder us even more so. So go ahead and close.
Well, let me respond to your statement. First of all, let me just say, and you know, I mean, very articulate presentation, you know, by the chamber. You know, they did good with that hire. But let me just say that in California, the 8th largest economy in the world, people. Well, yeah, but I understand people want to do business in California, but they ought to do business in California and ought to follow California law. And we just witnessed in the housing market how not paying close attention to clauses and contracts can get a nation in trouble. All we're talking about here is that if you're going to do business in California, then employees are subject to the California laws, and they don't have a choice of law provision. In addition to that, I would disagree respectfully with the chamber this way. I think this not only helps employees, I think it helps employers, because businesses are given a terrible disadvantage to other businesses that are operating under a different set of laws. And I think all California businesses should be on equal plane with the other companies that do business, whether they're located out of state or not. And so that's why I would say that this is about employees and employers having a level playing field, and that's why I would ask for your aye vote.
And one last question. Is there a concern, though, because when you have so many governors of Texas, Utah, Ohio, Florida, putting offices in California, recruiting our businesses away because of so much regulation and high taxes, does that put any kind of a concern in your?
Well, I don't have any phobia about regulations if there's a purpose, a public good purpose served by that. I think there is a public good purpose served by this. I don't think that it's fair for an employee or a low-wage worker in California to have to travel to New York to defend themselves. I just don't think that's acceptable, and I think that these clauses need to be clear, and they don't need to be forced upon employees. So we're asking for a fair standard, and I think that if you were working in California and you signed a contract and you had to go to New York to defend yourself, I just think that you would see that as problematic, and so that's the kind of things we're talking about addressing.
And I would agree. I think the fairest way for businesses coming and doing business in California, that if there's some dispute, that the fairest place to resolve that dispute is going to be in a court in the jurisdiction of where that business is located. Yes. And from a small business point of view, I could just imagine somebody in my small town, from Salinas, that signed into a contract for an ag producer in Florida, and they didn't realize that there was an obscure provision in that contract that said all their claims have to be handled in Connecticut or Florida. What does that mean for the small business owner? They're going to have to hire an attorney that's licensed to practice in that particular state, and then all the travel expenses to go to the multiple hearings that are involved in litigation. So it ends up being a very major expense for the business community as well.
Is there a motion?
I moved already, and there was a second.
Take roll call, please.
Swanson?
Swanson, aye.
Swanson, aye. Morel? No. Morel, no. Alejo? Aye. Alejo, aye. Allen? Aye. Allen, aye. Furutani? Aye. Furutani, aye. Gurel, Yamada? Yamada, aye.
Sorry? Yeah, Mr. Chairman, I have two more bills. AB 1396, employment contracts. AB 1390, huh? Oh, sorry. AB 1396 eliminates an unconstitutional inconsistency in current law which exempts employers residing and conducting business in our state from putting employees' commission contracts in writing. Currently, employers who have no permanent fixed place of business in the state who enter into a contract or employment involving commissions as the method of payment with an employee for work done within our state to put the contract into writing as specified. However, California courts ruled that this is in violation of the Commerce Clause and Equal Protection Clause of the U.S. Constitution because it did not apply to in-state as well as out-of-state employers. And I'd like my witnesses to self-introduce.
Good afternoon, Mr. Chairman and members. Larry Doyle on behalf of the Conference of California Bar Associations. We're the sponsors of Assembly Bill 1396. Simply put, this bill exists to remove a trap for the unwary. We have a code section, Labor Code Section 2751, which purports to provide protections to California workers on a commission basis who now see the statute, try to rely on it, and then find that it's been held unconstitutional. The thing's still on the books. So the question is, do we restore the protections that code section purports to provide, or do we eliminate them? Those are the only two options. We believe that the proper thing to do is to restore those protections. The way to restore them is to make them generally applicable not only to businesses without a fixed place of business within California, but also to those in California. We've worked with the opposition through the course of last year with a related bill or predecessor bill, Senate Bill 1370 by then Senator Ducheney, and made a number of changes to provide clarification, to provide a grandfather clause for the effectiveness of the bill, to provide a means where commission contracts that exist continue that go on beyond the termination date or remain in force and effect so that people don't get sandbagged by having a commission contract cease. And we've done everything possible to make this reasonable, but to ensure that the workers who sign these contracts are protected. And with that, turn it over to my other witness.
Mr. Chairman, members, my name is Michael Sohigian. I'm a practicing lawyer in Los Angeles. I have represented parties in cases seeking payment of commissions that were not the subject of a written agreement. I have fallen into this trap for the unwary. And I am here to tell you that this is a bill that has been crafted with Mr. Doyle's very capable help and in consultation with opponents of the legislation to try to provide the protection for workers in this state and to provide protection for employers. All of the opponents, as well as Mr. Doyle and myself and the chairman, agree that written commission agreements are best business practices. And the commission agreement that is required or would be required under the legislation and that is required under 2751 as it currently exists in the Labor Code, although it has been held ineffective, simply requires a writing that states the method of computing and paying the commission. That's a relatively low burden, it seems to me, on businesses. And it doesn't seem likely that, provided that businesses are adequately informed, there's a grandfather clause here or a delayed onset clause, that it won't go into effect until January 1, 2013, which provides a long time for the business community to educate itself about these requirements. And the requirements, as I say, are really not very burdensome. So with that, I respectfully urge your aye votes. Thank you.
Chairman, I have a question. Mr. Swanson, how does this become a labor bill, labor committee bill? It's a labor committee bill, right? It's not a members. How does it become a labor committee bill? So the idea comes from where? Okay. It just, I mean, I can understand that it makes it more difficult when it's a labor committee bill. If it's member sponsored, you can go talk to the member, you know, about what's behind it, what's going on. That's why I wanted to know how it happens.
Good.
Sarah Fox from the California Labor Federation. In support of the bill, we just think that written contracts are an easy way to avoid disputes between employees and employer and avoid costly litigation. And we urge your support. Thank you.
Move the bill.
Good.
Any in opposition?
You may want to stay in case of the question.
Good afternoon, Mr. Chairman, members. Julianne Broyles here on behalf of the California Employment Law Council in opposition to AB 1396. We are very concerned about this bill because we believe this bill will basically set a trap for unwary employers and result in needless litigation in California. We understand the concept of certainty and predictability, but the tremendous variety of compensation practices in this state, including commission practices, there are literally thousands and thousands of different kinds, and they might be interpreted to be commission agreements. This bill basically would subject them to enormous penalties should they run afoul of it. We do believe that compliance would be a problem because of the variety of commission programs that might be affected like this, and we don't think this is a problem that is fixed by making another only in California law. The statute was removed because it interfered with the Commerce Clause of the U.S. Constitution. We don't think it's in any way a benefit to California employers to have yet another only in California requirement put on their pay practices in this state. For this reason, we're asking for a no vote.
Hi, members. Jennifer Barrera on behalf of the California Chamber of Commerce. We are not necessarily opposed to putting a commission agreement in writing. We don't necessarily see, that being a problem for the employer and employee. What we are concerned with is the companion statute that comes along with AB 1396, which is Section 2752, and states that any violation, even a minimal violation, will result in triple damages against an employer. And it's not a discretionary damage on behalf of the judge, it's a mandatory. So even if we have a minor violation in the contract, an employee automatically gets 3 times the damages. Now, generally with contracts, if it's a breach of contracts, the whole point is to make the other party whole, not to give them a windfall, which this would do. In the case that invalidated the original section of the labor code that we're talking about, the court even referenced how it was surprised to see triple damages as the award, as that's not generally allowed for any contract. And notably, Civil Code Section 3294, which addresses punitive damages, states that if you're going to have a higher level of damages, the plaintiff or the moving party needs to have a higher evidentiary burden of proof, such as malice, oppression. This would automatically give them triple damages, which is akin to a punitive damage, without any showing that the employer intentionally tried to harm them, was malicious or oppressive in how they performed that violation or committed the omission. And so for those reasons, for the triple damages that will go along with this bill, we oppose it.
Go ahead. Yes, we'd like to. Okay, one more.
Sorry.
Did you want?
Catherine Pettibone, Civil Justice Association. We are opposing for the same reasons on the treble damages. It is punitive without that higher showing, and in contract law, that's pretty egregious.
Mark Powers with the California Broadcasters Association. We had worked with committee staff and had some reservations that are in the analysis. We think we can work with that, but we also have reservations about the triple damages, and so we must oppose the bill as well.
Please.
By way of response, this is Michael Sohigian again. Mr. Chairman, the treble damages are already in the law. That's Labor Code Section 2752, which is not before the panel today. Now, treble damages are a recognized penalty. They actually exist in other legislation that applies to commission agreements. Civil Code Sections 1738.10 through 1738.17 is the Independent Wholesale Sales Representative Act. It does not apply to people who sell directly to consumers on commission agreements. And so this simply would broaden, would have a somewhat broader application. But it also says that if the employer does not put a commission agreement in writing, that the employer will be liable for treble damages. So this is by no means a novel application. And the law of the state of California has long separated employment contracts from the general contract, which is, as the Chamber's representative said, a benefit of a bargain measure. But for violation of employment contracts, we have a separate regime of remedies that are available. And so she's really comparing apples to oranges, it seems to me, with apologies for the cliche. And one last thing. The variety of commission payment arrangements that the opponents have referred to is, it seems to me, adequately addressed by subsection C of the proposed legislation. It defines commissions using Labor Code Section 204.1, which was what the California Supreme Court applied in Ramirez versus Yosemite Water Company. So this, again, is an established definition established by the courts of this state, and it goes on to exclude short-term productivity bonuses, bonuses and profit-sharing plans. So it's pretty clear what is a commission under this statute and what is not.
Mrs. Broyles, is that correct?
Thank you, Mr. Chairman. To a certain point, there is a couple of points in there that I agree with. There's others that I would not agree. With the variety of commission agreements, again, the bill talks about bonuses. We're not talking about agreements. We're talking about commission agreements. That is not addressed. So if I have a sales incentive commission package for my employees, I would not be able, if it's a short term, saying that if you sell X number of tires between now and the end of May, the person who sells the most gets to go to Hawaii. That's not a bonus. That's an actual incentive package that could be determined to be a commission process. Again, because of the vagueness of the wording of this particular law. As to the issue of the treble damages, the provision that was taken out in the lawsuit 2752 applied to that. If we're re-establishing it, you're going to have the treble damages existing. So I think there's a little bit of splitting of hairs here, but we are very concerned about this, and somebody was upset they lost a button.
I have a question.
Okay.
Yes.
Yeah,
to the chair.
Any comments? Go ahead.
Yeah. So it kind of goes back to what Assemblymember Furutani was asked about earlier. So it seems to me that I support this bill. I understand why it's before us. I can understand why the Conference of California Bar Group brought it forward. I can understand that. But with a committee bill like this, where there's certain provisions where there's disagreement on facts, when I see people testifying and the opponents are shaking their head, maybe it's because there's a disagreement on facts. I don't know. But who... Does it go through the chair, the staff? Where do those conflicts get resolved? Does it go through you?
Yes. But what we try to do with bills like this, and this was going to be part of my close, but let me just tell you, what this bill does, it's clarifying that all commissions must be in writing.
And that's why I support the bill. I think it should be in writing.
And there are penalties associated, that are all part of current law. That's not new law in that sense. But and so to me, I think it's pretty straightforward. It's a pretty straightforward measure. We're open to look at whatever issues that have been raised here, but I think it's pretty.
I think it is straightforward, but sometimes with I think that's what's helpful when we have opposition or concerns is for the opposition or folks who have concerns to run hypotheticals and ask how is this going to apply, and something like that clarifies.
I think it's right.
Thank you.
Yeah, and I would say to everyone that we're open to look at any of the points that were raised here as the bill go forward, and the sponsors are certainly willing to sit down and have those discussions. No one's interested in developing something that's unworkable. We want to make sure that essentially, people get paid for what they do. I mean, right? Okay.
So this isn't a new law on top of an old law, then, or it is?
No, it's an extension of the existing law to make it effective. The only way you can do it is to extend what existed before with respect to companies outside of California to companies inside of California.
Well, yeah, that's correct, sir. And that was the choice that Mr. Doyle posed. What he said was.
Wait, look, talk to the mic.
What he said was because the district court invalidated the existing statute on constitutional grounds, there are two choices. Right now, the statute is on the books. 2751 and 2752 are on the books. Either you eliminate the protection entirely, which would seem to run counter to the expressed will of the legislature when it passed the statute quite some time ago. It looks like from the legislative report that it was about 40, 50 years ago. Or you modify the existing statute so that it doesn't run afoul of the Equal Protection Clause, which is applicable to the state of California through the Commerce Clause of the U.S. Constitution. And so the choice that we have made is to continue to provide the protections that the statute suggests are available to employees and employers by amending the statute as shown.
Would you like to close, sir?
Yes. I would say that this is about clarifying that all commission contracts must be in writing. The bill ensures the rights and earnings of California employees are protected and seeks to avoid disputes between employees and employers regarding commission compensation and an attempt to avoid costly time in court cases. And I would ask for your aye vote.
Okay, can we call the roll, please?
Swanson?
Swanson, aye.
Swanson, aye. Morel? No. Morel, no. Alejo? Aye. Alejo, aye. Allen? Aye. Allen, aye. Furutani?
Aye.
Furutani, aye. Gurel, Yamada? Yamada, aye. That bill is...
Mr. Chairman, I have one more bill. One more bill, yes.
Best for last.
Yeah, this one's simple. The bill seeks, AB 1399, this bill seeks to clarify and strengthen the law regarding an employee or former employee's ability to inspect their personnel records. Current law with respect to personnel records is very clear. Unfortunately, this is not the case with respect to the provision of the law regarding personnel records. The code is vague and unclear. In general, this bill attempts to conform the two. Our office has met with the opponents and have taken some amendments. We are taking 2 additional amendments today to address their concerns. We are increasing the time for production from 21 days to 30 days. We're adding language to provide that inspection is cut off if there's a lawsuit pending and discovery rules apply. Since our last meeting, the opponents have raised 3 or 4 additional issues of concerns, and we promise that we will look at those also. I would ask my witness to self-introduce.
Mr. Chair and members, Mark Schock, California Rural Legal Assistance Foundation, here on behalf of us as the sponsors of this bill. This is the second time this bill will be moving through the legislature. And what it simply does, as the chairman said, is it makes the current right of inspection of personal records more meaningful, and particularly for people who don't read or speak English. Most of our clients are monolingual in Spanish or in indigenous Central American language. The recent census summary that surfaced at the beginning of the year showed that 42% of California families speak a language other than English at home, and that there are more than 300 languages and dialects being spoken in California schools. For those Californians, the right to inspect is virtually meaningless because the records are all in English. We have tried to, as the chairman also said, conform this bill to a previously negotiated bill that related to access to copies of pay stubs and payroll records. We negotiated that with the Chamber of Commerce and the Farm Bureau more than 2 decades ago, and the most recent concerns expressed by opponents relate to problems that we think would have arisen under that earlier statute with similar provisions if they were going to occur at all. But we, as the chairman said, we're willing and interested to continue talking with them. This is an important bill for California workers.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We'd agree this really is primarily an issue of language access and of making these rights meaningful for all workers. Thank you.
Yeah.
No.
Good evening, members. Jennifer Barrera on behalf of the California Chamber of Commerce. And we do want to say up front that we have been working with the author and the sponsor, and we appreciate their work on this bill so far to help alleviate our concerns. There are a few remaining outstanding concerns that we're hopeful that we can work out, and I just want to briefly go over those very quickly. One of them being there's a $750 penalty associated, and that's a strict penalty that will be imposed if you don't comply with these requirements. It allows former employees to request their personnel records, and there's no limit on how many times they can request those records, even though a former employee's personnel records aren't going to change. Once they're done, once they're terminated, their personnel records are going to maintain the same. So we believe there should be some type of limitation put on the number of requests that can be made by a former employee so that we're not running the risk of getting that $750 penalty. The other concern that we have is for larger employees who maybe have hundreds of employees making these requests in a month or a week period, and they have 30 days to comply with it. It could be a personnel issue on their own part of trying to comply and get all those records. These records aren't always located on site. For larger employees, they're often off site, stored somewhere, and to access all of those records for multiple requests could be problematic for them. And if they don't comply, then they're automatically hit with the $750. So we're concerned on that. The other issue is that this bill allows, at the discretion, from our reading, of a former employee to either request to come onto the site and inspect those records or to get a copy. Our concern is that if it's a former employee who has been terminated for workplace violence, harassment, or some other dangerous violation of some kind, even though a temporary restraining order is out, to allow them to have access onto the premises is a concern because we don't want to invite them back onto our premises. So to eliminate that option and just have copies sent to them would be a better option for the employer. And for those are the concerns where, again, we're hopeful we can work those out with the sponsor and author. Thank you.
Good afternoon, Mr. Chairman, members. Julianne Broyles here on behalf of the California Employment Law Council one last time. Certainly we agree with the concerns raised by the California Chamber, and in fact, as Mr. Schott will be shake his memory loose, I was the person who worked on that bill with you to get the original bill, and some of the issues that we agreed not to, well, I had a different color hair and he was younger too.
Touche.
There you go. Essentially, many of the issues that we agreed to disagree on and have removed from the original bill are surfacing back again in AB 1399, and it is of concern. We did at the time offer the fact that if you had a limited English speaker, that a representative might be someone that you might be able to turn to and have help look through the file. But keep in mind, in this electronic age, personnel files are not really a file. They're not set in a manila folder where every piece of information on an employee is kept in that item. It is whether they've gone through training for their IIPP program, that's with someone who handles the CalOSHA for a larger employer. If it's dealing with I-9 issues, that might be a compliance officer, and that might have that in there. So it's one of the troubling issues. What exactly is this personnel file that you're trying to get at? And I know it's been brought up in discussions before, but in many ways, this bill is a way of lazy man's discovery because you're going to be able to go through these files up until the time you have a lawsuit filed, which I believe is an amendment that is being taken by the author, correct?
I'm sorry,
I'm sorry, we were consulting.
Yes, on that particular issue, and we're glad to see that addressed. But we do think that there are some concerns going with this. We would like to be able to work with the author on it and find a way to address limiting access really to those people who need to have it, the employee themselves, and if they have an English as not their primary language, have a way to have that representative in there. But other people, quite frankly, employers do not want people who are not associated with their business operations going through their personnel files. I mean, it's an issue of privacy. There are things in there that other employees might be mentioned in reports. You just don't want to have their privacy interfered with as well. So for all of those reasons, we would like to oppose the bill and still be able to work with the author as the bill moves forward.
Yeah, and I would say in response that obviously we're open to doing that. We're open to the issue of security, you know, in terms of you know, an employee where there's a restraining order and all those kinds of, we're very open to that. Matter of fact, I think we're working on some language to look at that question. The $750 fine. I mean, I think it's been on the books for two decades or something. Right?
That was actually.
Yeah, I mean, so that's, and I don't know, do you want to add something else?
Well, it should be more. The whole point of the fine was a deterrent, right?
Yeah, right. So anyway, it says 750, and it's
So we
been there.
compromised by not making it more.
Yeah, it's been there for 20 years. But in terms of talking about these things, since you're used to negotiating with your friend here, you guys continue to do that, and we will remain open to you guys have coffee, I'll pay for it.
Comments from the committee members?
I just wanted to thank the author and the different interested parties working and demonstrating good faith, bringing these amendments forward. But I did want to clarify a point that was said earlier, that it was an automatic $750 fine. It's not. It's only if a claim is actually filed in court that they could be subject to that, because like they gave the records on day 32, the prisoner's going to be happy they got the records. No fine is going to be imposed unless it gets to a point where litigation is actually filed. Then a judge might impose those penalties. Only at that point in those very limited circumstances.
Mr. Leo, you can be my lawyer anytime, and you're absolutely correct.
Just in the interest of accuracy, it could also go before the Labor Commissioner, but that would still result in a hearing and a finding and an opportunity to appeal.
Absolutely.
And none of that will be invoked if the worker gets the records.
Right.
Can we call the roll, please? Were we done? You want closings?
Yeah, I just want to say thank you. We're open, committee members, as is the case with me and all my legislation, to continue the conversations as the bill moves forward. We want a good bill. We want a good law, and we're not trying to develop any traps for employers. We're just trying to make sure the system is fair. Okay, thank you, and I ask for your aye vote.
Swanson?
Swanson, aye.
Swanson, aye. Morel? Morel, no. Alejo? Aye. Alejo, aye. Allen? Allen, aye. Furutani?
Aye.
Furutani, aye. Gurel, Yamada? Yamada, aye. That bill is out.
Okay, thank you.
We done?
Just about. One second.
Lift the call. I'm not impatient. Sorry.
It's been a long day for all of us, Mr. Morrell. You're right. These last conversations, I don't know what the hell they were talking about. And then that legal.
Okay, we're
Mr.
Leo. Okay,
Luis.
I just don't. This is our last hearing, and I don't want to kill anybody's bill inadvertently. So we're going to lift the calls on two bills. What are the numbers? 302. AB. What number?
Item number 3.
We're lifting the call on AB 302. Chair voting no. Call the absent members.
Alejo?
No.
Alejo, no. Gurel?
What's the next? Bill fails. Bill fails. And what is the next?
AB 830.
AB 830 with the chair voting no. Lift the call for absent members.
Alejo?
No.
Alejo, no. Gurel? That bill fails. Oops.
Okay, so that bill
Fails.
That bill fails. Is that the end of business?
Yes.
Okay.
Adios.
Without objection.
It's already been requested.
Okay, without objection. Anything else, Mr. Morrell? You did a great job, Mr. Morrell. Thank you. That Swanson guy was a little hard to handle, though. All right, thank you. Meeting stands adjourned.